These days, it is universally agreed in Australia that consent to sexual intercourse is as necessary within a marriage as it is outside a marriage. But as late as the 1990s, the law didn't seem to agree. As long ago as the 1600s, it was asserted by Sir Matthew Hale that a man could not be prosecuted for raping his wife. Various rationales were advanced: that the bride had irrevocably consented to sex in her marriage vows, that she had no separate legal personality from her husband, that marriage embodied a right to sex. These were equally ridiculous from a modern perspective, but they held sway for centuries. In 2010, the appellant PGA was charged with having raped his ex-wife while they were still married in 1963. There are obvious problems with how someone gets a fair trial for events 50 years previously. But setting those issues aside, should PGA be tried according to the common law of 1963 or of 2010? The majority judges seem to have been understandably influenced by the need to avoid any perception that they would tolerate marital rape. They found, contrary to the historical record, that marital rape immunity had not been part of South Australian law since at least 1936. Justices Hayden and Bell were not convinced. Neither of them considered that marital rape was acceptable. Their concern was that retrospectively imposing criminal liability for something which was commonly considered lawful was contrary to basic principle, and that, tragically, in 1963, nobody would have ever considered prosecuting a husband for raping his wife. Justice Hayden, in particular, turned to the great thinkers of jurisprudence to support his views, citing a number of eminent legal philosophers, including perhaps the most notable Australian legal philosopher, John Finnis, who said, "The administration of the criminal law's prohibitions is permeated by rules and principles of procedural fairness, due process of law, and substantive fairness, desert or proportionality, which very substantially modify the pursuit of the goal of eliminating or diminishing the undesired forms of conduct, including the principles which outlaw retroactive proscription of conduct at the known cost of letting some dubious characters slip through the net." In other words, if the criminal law is to embody justice, sometimes wrongdoers will get away with their crimes, but this is far better than the alternative, a society of unstable criminal laws which cannot be relied upon.